Chapter 5: Obligations of the Vendee. The previous group discussed the obligations of the vendor. In this chapter, we will learn that not only the vendor has obligations, but the vendee as well has obligations, rights, and remedies. Article 1582 of the Civil Code of the Philippines outlines the principal obligations of the buyer in a contract of sale. It emphasizes the buyer's duty to accept delivery and pay the price of the thing sold, as well as to bear certain expenses related to the transaction. The primary obligations of the vendee first is to accept the delivery. The buyer is obligated to accept delivery of the thing sold at a time and place stipulated in the contract. This duty is paramount in ensuring the buyer fulfills their part of the reciprocal obligation in a contract of sale. Second is to pay the purchase price. The buyer must pay the price of the thing sold at a time and place stipulated in the contract. If no time or place is specified, then payment must be made at the time and place of delivery. The third obligation of the vendee is to bear the expenses. The buyer is bound to bear the expenses for the execution and the registration of the sale, as well as any expenses incurred in putting the goods into a deliverable state if stipulated in the contract. Article 1582 further provides that the vendee shall pay interest on the price from the time it becomes due in three specific cases. First, if so stipulated in the contract. Second, if the thing sold produces fruits or income from the time of delivery, or if the vendee is in default from the time of judicial or extrajudicial demand. In cases where the sale involves agricultural products or income-generating assets, the vendee bears the burden of interest to compensate the vendor for the opportunity lost. However, if the vendee proves that the delay in payment was due to the vendor's fault, such as non-delivery, then interest may be excused. Always remember these pertinent rules. In a contract of sale, the vendor is not required to deliver the thing sold until the price is paid, nor the vendee to pay the price before the thing is delivered in the absence of an agreement to the contrary. Second, if stipulated, then the vendee is bound to accept delivery and to pay the price at the time and place designated. Third, if there is no stipulation as to the time and place of payment and delivery, the vendee is bound to pay at the time and place of delivery. Fourth, in the absence also of stipulation as to the place of delivery, then it shall be made wherever the thing might be at the moment the contract is perfected. And lastly, if only the time for delivery of the thing sold has been fixed in the contract, the vendee is required to pay even before the thing is delivered to him. Article 1582 is fundamental in ensuring that buyers fulfill their obligations in a contract of sale. It establishes a clear framework for delivery and payment, promoting fairness and accountability in every transactions. Article 1583 of the Civil Code of the Philippines addresses the buyer's rights and obligations in installment sales of goods. It emphasizes that buyers are not bound to accept goods in installments unless explicitly agreed upon in the contract. However, if such an installment arrangement exists, the article outlines how breaches in the contract are treated, focusing on whether the breach is material, which would justify termination, or severable, wherein allows compensation without contract termination. As a general rule, in an ordinary contract of sale of goods, the buyer is not bound to receive delivery of the goods in installments. He is entitled to deliver of all the goods at the same time and is bound to receive delivery of the goods at the same time. Similarly, a buyer has no right to pay the price in installments. Neither can he be required to make partial payments, except if there is an agreement goods may be deliverable by installments or the price payable in installments. This protects buyers from being forced into accepting partial deliveries that may not meet contractual standards. In installment sales contract, if the contract stipulates delivery by stated installments, each installment must be separately paid for. This creates a clear financial structure for both parties. For breach of contract, if the seller makes defective deliveries in one or more installments, or the buyer neglects or refuses to accept or pay without just cause, the consequences depending on the materiality of the breach. As stated earlier, if the breach is material, when we say material breach, the breach is significant enough to justify termination. The injured party can refuse to proceed further and sue for damages for breach of the entire contract. When we say severable breach, the breach is minor and does not affect the entire contract. The injured party may claim compensation for the specific breach but cannot treat the entire contract as broken. For the buyer's protection, buyers are shielded from being compelled to accept defective installments. They can demand full compliance with the contract terms. As to sellers' accountability, sellers must ensure that each installment meets quality standards. Defective deliveries risk contract termination or financial penalties. As to contractual terms and circumstances, the severity of a breach is determined by the contract's specific terms and the circumstances of the case. For example, if a buyer agrees to purchase 100 units of goods in 10 installments, each to be paid upon delivery, and the seller delivers defective goods in the first installment, the buyer can terminate the contract if the defect is severe and renders the remaining installments unreliable. On the other, another remedy for the buyer, he can claim compensation if the defect is minor and only affects the first installment. Article 1583 provides a balanced framework for installment sales. It protects buyers from unfair practices while holding sellers accountable for fulfilling their obligations. The distinction between material and severable breaches ensures that minor issues do not unnecessarily disrupt long-term agreements.
Good day everyone, I'm going to report Article 1484 which states that in a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. First, exact fulfillment of the obligation, should the vendee fail to pay. Second is the cancel of the sale, should the vendee's failure to pay cover 2 or more installments. Third is the foreclosure of the channel mortgage on the thing sold. If one has been constituted, should the vendee's failure to pay cover 2 or more installments. In this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. So, the requisites of Article 1484 The requisites of Article 1484 may be applied. So first, there must be a contract. Second, the contract must be one of the sale. Absolute sale, not a pacto di retro transaction, where redemption is effected in installments. What is sold is personal property. Sale of real property in installments is governed by RA 6552 or the Masada Law, which took effect on the date of its approval. So, the sale must be on the installment plan. An installment is any part of portion of the buying price, including the down payment. So, let's take note that if the sale is for cash or straight terms, hereafter an initial payment, the balance is paid in its totality at the time specified, say 2 or 3 more months later. This is also considered a cash sale, and Article 1484 does not apply. So the purpose of Article 1484 is the protection of the sale of personal property in the installment plan. So Article 1484 or direct to law exists. It stops sellers from foreclosing a chattel mortgage at a law auction price and then suing the buyer for the remaining balance. If that were allowed, the buyer would lose the property and still owe money. An abusive double hit. Rectal law solves this by making the seller choose among exclusive remedies, and if the seller chooses foreclosure of the chattel mortgage, it bars any auction for deficiency. The point is to prevent double recovery and protect installment buyers. In the case of Barrach Motor versus Milan, before the rectal law, sellers in installment sales of movables could both foreclose and sue for deficiency, creating the abuse. The law was designed to curb. The case is often cited to show the problem. The rectal law corrected and reinforced the policy rationales. Buyers shouldn't end up propertyless and still indebted. Rectal law changed the landscape in which once foreclosure is chosen, the seller must accept that the auction proceeds as full satisfaction. It means no deficiency suits. Let's take note here that the remedies enumerated are alternative, not cumulative. So I will discuss the remedies one by one so that everyone should understand. So first, in the first remedy cited in Article 1484, this remedy is available when the buyer fails to pay one installments. It can be enforced through action of specific performance or the ordinary civil action for the recovery of the unpaid balance. The seller is not limited in the proceeds of the sale. He can still recover from the buyer the unpaid balance. So, let's also take note that if the seller chooses this remedy, he cannot avail the other remedies in this article since the nature of the remedies is alternative, not cumulative. Second, available when the buyer fails to pay 2 or more installments. Second remedy is enforced through rescission of the contract. It is a mutual restitution. So the effects of the rescission of contracts is the mutual restitution, in which if the seller chooses cancellation, it is needed for both parties to return the things received by each of them. And it creates an obligation to return the thing which is the object of the sale or contract. And lastly, in the third remedy is that it is available when the buyer fails to pay 2 or more installments. The seller cannot ask or recover the unpaid balance. So, we should be in mind that there should be an actual foreclosure in order for the unpaid seller to be barred from electing the other two remedies. Article 1485. The preceding article shall be applied to contracts purporting to be lease of personal property with option to buy, when the lessor has deprived the lessee of the possession or enjoyment of the thing. This provision extends Article 1484 or Director Law, which governs sales of personal property payable in installments, to certain lease with option to buy contracts. So why Article 1485 exists? It exists basically because to prevent circumvention of rectal law, meaning sellers used to disguise installment sales as leases with option to buy to avoid the protections of Article 1484. Second, it is a reality over form, in which the law looks at the substance of the transaction. If the lease is really just a way to stagger payments towards ownership, Article 1485 applies. In the protection of buyers and leases, it ensures that once the lessor repossesses the property, they...
Good evening, everyone. My topic is about the continuation of Chapter 5, the obligations of the Vendee. The Article 1586. This article provides that in the absence of express or implied agreement of the parties, acceptance of the goods by the buyer shall not discharge the seller from liability and damages or other legal remedy for the breach of any promise or warranty in the contract of sale. But if, after acceptance of the goods, the buyer fails to give notice to the seller of the breach in any promise of warranty within a reasonable time after the buyer knows or ought to know of such breach, the seller shall not be liable therefore. So this article is all about the notice to seller of breach of promise or warranty. This article requires the buyer, in order to hold the seller liable for breach of promise or warranty, to give notice to the seller of any such breach within a reasonable time. Time is counted not simply from the moment the buyer knows of the defect, but from the time when he ought to have known it. Prompt exercise of opportunity for discovering defects is therefore essential. So what is the purpose of giving notice to seller of breach of promise or warranty? The purpose is to protect the seller against belated claims which prevent him from making prompt investigation to determine the cause and extent of his liability, and also to enable him to take any immediate steps that his interest may require. Next article is Article 1587. This article provides that unless otherwise agreed where goods are delivered to the buyer and he refuses to accept them, having the rights so to do, he is not bound to return them to the seller. But it is sufficient if he notifies the seller that he refuses to accept them. If he voluntarily constitute himself a depositary thereof, he shall be liable as such. So, this article is about where buyer's refusal to accept is justified. So first, duty of buyer to take care of goods without obligation to return. If the goods have been sent to the buyer and he rightfully refuses to accept them, as in the case where the goods are of not the kind and quality agreed upon, he is in the possession of a bailee who has had goods thrust upon him without his assent. Doubtless, he has the obligation to take reasonable care of the goods, but nothing more can be demanded of him. Accordingly, he is under no obligation to return the goods to the seller. Next is the duty of seller to take delivery of goods. After notice the goods have not been and will not be accepted, the seller must have the burden of taking delivery of said goods. Third is the seller's risk of loss of goods. While the goods remain in the buyer's possession under these circumstances, they are of course at the seller's risk, but the buyer is not deemed and is not liable as a depositary, unless he voluntarily constitutes himself as such, in which case he may safely take care of them in the meantime. Next is the right of buyer to resell goods. After the seller, when notified to take delivery of the goods, fails to do so, the buyer may resell the goods. The provisions governing resale by the seller when the buyer is in default, it seems, will generally be applied. So, that would be all for my topic of this chapter. Thank you and good evening.
Good evening, everyone. I will be discussing Articles 1588 and 1589 of the Civil Code of the Philippines. These provisions deal with two important concepts in the law on sales. What happens when the buyer refuses to accept the goods without a valid reason, and when the buyer or vendee becomes liable to pay interest after delivery of the thing sold. Article 1588 states that if there is no stipulation as specified in the first paragraph of Article 1523, when the buyer's refusal to accept the goods is without just cause, the title thereto passes to him from the moment they are placed at his disposal. This article talks about the effect of unjustified refusal to accept delivery. What happens if the buyer refuses to accept the goods without just cause? General rule: the buyer becomes the owner. This is true even if the buyer refuses to accept the goods in case his refusal is without just cause. The title passes to the buyer and therefore the risk of loss is borne by him from the moment they are placed at his disposal. Example: If the seller delivers the goods to the buyer's warehouse and the buyer unjustifiably refuses them, and the goods later get damaged or lost, the buyer bears the risk because ownership has already passed. Exception: when there is a contrary stipulation or when the seller reserves the ownership as a sort of security for the payment of the price. This means that the parties can agree that ownership remains with the seller until the buyer pays. Article 1589 states that the vendee shall owe interest for the period between the delivery of the thing and the payment of the price in the following three cases. First, should it have been so stipulated? Second, should the thing sold and delivered produce fruits or income? Third, should he be in default from the time judicial or extrajudicial demand for the payment of the price? This article talks about the liability of vendee for interest after delivery. It explains the three situations when the buyer is required to pay interest from the time the thing is delivered until the price is paid. First, we have when interest has been expressly stipulated. In such case, the rate stipulated governs. The stipulation of the parties to pay interest may be oral. Article 1956 of the Civil Code, which provides that no interest shall be due unless it has been expressly stipulated in writing, should be construed applicable only to contracts of loan. If the parties fail to fix the rate, then the legal rate of interest shall be due. No demand is necessary. The second one, when the thing sold produces fruits or income. Under number 2, two conditions must exist. First, that the thing sold has been delivered, and second, that it produces fruits or income. If the vendee would not bound to pay interest for the use of the money, which he should have paid, the principle of bilaterality which characterizes a contract of sale would no longer exist. Since the law makes no distinction, the vendee is still bound to pay interest even if a term has been fixed for the payment of the price. The reason is that the fruits or income is sufficient to warrant the payment of interest. No demand is necessary. The third one is when the vendee is in default. If the vendee incurs delay in the payment of the agreed price, the interest is due from the time of judicial or extrajudicial demand by the vendor for the payment of the price. This demand by the vendor is the starting point for the commencement of default or delay on the part of the vendee. For example, if the seller sends a written demand for payment on March 1, the interest starts running from March 1. To summarize Articles 1588 and 1589, Article 1588 talks about if the buyer refuses the goods without a valid reason, ownership and risk of loss transferred to him unless there is an agreement stating otherwise. For Article 1589, when the buyer must pay interest after delivery in three situations: when interest is stipulated, when the thing produces fruits or income, and when the buyer is in default after demand. These rules ensure fairness between the seller and the buyer and maintain the mutual obligations that define a contract of sale. Thank you.
Let's proceed to Article 1590. Should the vendee be disturbed in the possession or ownership of the thing acquired, or should he have reasonable grounds for fear such disturbance by a vindicatory action or a foreclosure of a mortgage, he may suspend the payment of the price until the vendor has caused the disturbance or danger to cease, unless the latter gives security for the return of the price in the proper case, or it has been stipulated that, notwithstanding any such contingency, the vendee shall be bound to make the payment. A mere act of trespass shall not authorize the suspension of the payment of the price. So to further understand what is Article 1590 all about. So let's discuss what are the things or what are the option of a vendor in paying the price. So the first one is when vendee can suspend payment of price. So kanus aman maundang mahunong ang pagbayad ni vendee sa vendor sa item nga ilahang gikasabutan. So it might be in a one-time basis baka ni or in an installment. So the first one is if he is disturbed in the possession or ownership of the thing bought, or let's say nga na ay nagkasinabot na mo si Pedro o si Maria, nagkasinabot nga ibaligya ni Maria ang iyahang sakyanan. And then niabot sa picture si Juan nga niingon kang Pedro nga anong imo man ang paliton Pedro nga ako man ang sakyanan dili na siya kang Maria. So as a vendee you have the right to suspend the payment of the price. And the right that has a in the first statement is it is only the right to suspension, the right to suspend payment. Entire take for an instance, nag-installment basis nakagbayad sa worth 1 million nga saman Lamborghini. Nag-installment nagbayad o sa 1 million nga Lamborghini si Pedro kang Maria. Under these circumstances, provided in Article 1590, the vendee is only entitled to retain the price that has not been paid to the vendor. So, ang imong mga nabayad kang ang entire take for instance si Pedro nakabayad na kang Maria through installment. Ang mga bayad na niyang ni Maria is dili na niya mabakwi. But ang ihara nga right is the right to suspend the payment. So dili man ni siya applicable for right to rescission. And the second one is if he has a well-grounded fear that his possession or ownership would be disturbed by a vindicatory action or foreclosure of mortgage. So take for an instance nagkuan ka og house and lot nabaligya si gamito nagpud gihapon nato si Pedro, Maria ug Juan. So let for instance si Maria nagbaligya og house and lot kang Pedro. Then ang ilang kasabutan is the payment is in installment basis. So let's say nga good for a year. So 12 months ang imong gibayaran to ni 12 months ang kanang sa term ana ang installment payment nimo. Ang installment payment ni Pedro kang Maria. Then ay kuan came into the picture. Nga for example si Juan is manager of a bank nga ningon niya Mr. Pedro, the house and lot nga imuhang gibaligya ay gipalit ni Maria is naka-mortgage sa bangko. So as a vendee nga si Pedro, so he has the right to suspend the payment of the house and lot. So the next instances is when vendee cannot suspend payment of price, so dili na siya makapaundang. So the first one is if the vendor gives security for the return of the price in the proper case. So tagaan ka o peace of mind sa imong vendor nga take for an instance na third party nga nagsamok-samok. So si vendor ang ning settle. Then the second one is it has been stipulated that notwithstanding any such contingency, the vendee must make payment. So it is stipulated in the contract or the agreement that both of you had agree. So tuloy-tuloy lang gihapon taog bayad. So on the third one is if the vendor has caused the disturbance or danger to see. So napaundang ni vendor ang napaundang ni vendor ang mga kasamok sa third party nga nagsamok-samok sa inyuhang transaction between the vendor and the vendee. And the fourth one is if the disturbance is a mere act of trespass. So, but trespassing lang tug nag-angkon-angkon no sa kanang property nga imuhang paliton sa vendor. And the last one is if the vendee has fully paid the price. So, nabayaran na nimo. So, wala na kay kapaingnan kung dili ipadayo na lang kay nabayaran na nimo tanan. So if the thing is sold in the possession, if the thing sold is in the possession of the vendee and the price is already in the hands of the vendor, the sale is consummated contract and Article 1590 is no longer applicable, and it presupposes that the price or any part thereof has not yet been paid and the contract has not yet been consummated. So let's proceed to 1591. So 1591 states that should the vendor have reasonable grounds to fear the loss of immovable property sold and its price, he may immediately sue for the rescission of the sale. Should such ground not exist, the provision of Article 1191 shall be observed. So in this case, di ba, ang 1590 is for the vendee and this 1591 is for the rights of the vendor. So let's take and let's kuan sa about 1191. So 1191 is about reciprocal obligation where the vendor and the vendee is considered as obligor to each other. So let's have for an instance nga nagpalit og balay si Pedro kang Maria. Then ang ilang sabot is 12 months payment nga bayaran ni Pedro, impasan ang balay nga gibaligya ni Maria. Then on the third month wala nakabayad si Pedro because Pedro is into gambling, so na loss of funds siya, so wala na siya ikabayad kang Maria. So Maria as the vendor, she has the right to act immediately, no? Nga sige, ato na ni siyang kuanon, ato na ni siyang undangon. So it has the right of the vendor, no, nga to what do you call this, to stop, to rescind the sale of the house.
Article 1592. Article 1592 provides that in the sale of immovable property, even though it may have been stipulated that upon failure to pay the price at the time agreed upon, the rescission of the contract shall right take place. The vendee may pay even after the expiration of the period as long as no demand for the rescission of the contract has been made upon him, either judicially or by a notarial act. After the demand, the court may not grant him a new term presentation. The general rule: the vendor must sue for the rescission of the contract should the vendee fail to pay the agreed price. The sale of real property, however, is subject to the stipulations agreed upon by the parties and to the provisions of Article 1592. Before the demand of the rescission of the contract has been made by the vendor, the vendee must still pay the price even after the expiration of the stipulated period for payment, or notwithstanding a stipulation that failure to pay the price on the stipulated date ipso facto resolves the sale. The right to rescind is not absolute, and the court may extend the period for payment. Once a demand for rescission by suit or notarial act is made, however, under Article 1592, the court may not grant a new term. Article 1592 does not apply on sales, an installment of real property, and a mere promise to sell, where the title remains with the vendor until full payment of the price. In other words, the vendor in such cases may no longer pay the price after the expiration of the time agreed upon, although No demand has yet been made upon him by suit or notarial act. Article 1593 provides that with respect to movable property, the rescission of the sale shall of right take place in the interest of the vendor. If the vendee, upon the expiration of the period fixed for the delivery of the thing, should not have appeared to receive it, or having appeared, he should not have tendered the price at the same time unless a longer period has been stipulated for its payment. In case of personal property, the vendor can rescind the contract as a matter of right if the vendee, without any valid cause, does not accept delivery or pay the price unless credit period for its payment is stipulated. The mere failure of the vendee to comply with the terms of the contract, however, does not rescind the same. It is necessary that the vendor should take some affirmative action indicating his intention to rescind. Reason for the difference is that personal property are not capable of maintaining a stable price in the market. Their prices are so changeable that any delay in their disposal causes the vendor great prejudice. In the case of real property, which has more or less stable price in the market, and the delay that might result from the requirement imposed on the vendor to demand rescission before being entitled to rescind the contract will not in any way prove detrimental to the interests of the vendor. That's all. Thank you and good evening.